2019 and filed on the same date. By paragraph 22 of the statement of facts, the claimant's claim against the defendant is as follows. 1. A declaration that the dismissal of the claimant of 18th day of July 2016, not having given an opportunity to be heard nor queried for once, is unfair, unjust, unconstitutional, illegal, null and void. 2. An order of court directing second defendant to reinstate the claimant. Alternatively, an order of court retiring claimant as he was due for retirement in November 2019 on ground of old age, and an order deeming his retirement proper by affliction of time. An order of court directing defendant to compute and pay claimant all his terminal benefits, entitlement in both special and general exemplary damages assessed at 56,765,000 naira, less gratuity and arrears of pension yet to be computed and added. Special damages, salary arrears at 150,000 per month between 18th day of July 2016 to 18th day of November 2019 at totaling 615,000 naira. Monthly incentive of 15,000 naira per month between 18th of July 2016 to 18th of November 2019. Monthly pension from the month of December 2019 onward. 20 million for fiscal stress occasioned claimant and his entire family over years of displacement. General exemplary damages assessed at 30 million naira for embarrassment and trauma claimant to claimant's family, to claimant and his family. An order compelling defendant to strictly abide by the contemporary framework on enhanced compensation package on occupational health and safety in the computation of claimant's terminal benefit and compensation. Let me say at the onset that following the striking out of the first defendant from this suit by the order of this court, we are left with only sole defendant. Counsel for the parties have not amended their processes to reflect the true positions of the case, since the court granted the since the court struck out the name of first defendant. Therefore, in this judgment, any reference to defendant means reference to the only remaining sole defendant in this case. This means that I shall be referring to second defendant as defendant only, since we have only single defendant and not second defendant as counsel in the matters have been doing in their respective addresses. The defendant, with the order of the court, filed its statement of defense out of time on the 18th day of May 2022. The claimant testified in proof of his case as CW1. CW1, after identifying his witness statement on oath, adopted same as his evidence in this case. He also tendered documents which were admitted in evidence and marked as exhibit accordingly. Reference will be specifically be made to any of the exhibits in the course of the judgment. The claimant's case before the court is that he was employed by the defendant and served the organization diligently without any blemish, and that throughout the period of his employment, he was never served a single query letter, nor tried for any offense to date of filing the suit. In the course of his service, he was promoted 4 times up to the rank of chief guard detectives in 2014. On 5th day of June 2001, claimant was issued with certificate of commendation, and on 17th day of June 2009, after close of work, on his way home in the vehicle of the defendant, they had a ghastly motor accident wherein he broke his left leg, and went into coma instantly. He was rushed to the University of Calabar Teaching Hospital at the time when the doctors were on strike. He was hospitalized for 6 days without proper medical attention. Upon regaining consciousness, a nurse proposed amputation of his leg, but he resisted and asked to be taken to local bone setters in Calabar, where he had some relief, but not total. Following this treatment, he was able to limp to office despite the permanent disability that was caused to his leg. The claimant admits that the pain on the fractured leg has this annoying habit of recurring at intervals. Yeah, this was the case when he sought the kind permission of the authorities at his command around the month of February 2016 to attend to his health, to go to his village during treatment of his leg. However, based on this request, he was advised to apply for annual leave, which he did and was granted. But surprisingly, barely 15 days into the annual leave period, he got a call from the office in Calabar urging him to hurry back to the command office in Calabar, as a team from Abuja was on visit for staff verification. But before the claimant could limp back to Calabar, he was told that the team had left. Thereafter, claimant resumed duties and was collecting his salaries without query or any trial whatsoever until about 7 months later. On one occasion, he reported for duty only to be served with a letter dated 18th day of July 2020, dismissing him from service. The claimant had served for 19 years as at the time of his dismissal and ought to have retired from service in November 2019 on ground of old age. When Felicia Abeng testified in the defense of the defendant as DW1 after identifying her witness statement of 6th day of February 2022, adopted same as her evidence before the court. DW1 tendered 3 documents which were admitted in evidence and marked as exhibit D1, D2, and D3. She was cross-examined by counsel for the claimant, and thereafter she was discharged. The second witness that testified in the defense of the defendant as DW1 is one Nuhu Chindali, in charge of admin. DW2, after identifying his witness statement on oath of 6th day of February 2020, adopted it as his evidence in this case. He also tendered exhibit which were admitted in evidence and marked as exhibit DA, DX. The defense of the defendant is to the effect that the claimant's years of service were characterized by several entries of offenses against discipline committed by the claimant. He also undergoes orderly room trials. However, leniency was exceptionally short on the claimant, and the claimant was not dismissed as recommended. The claimant remained unrepentant and continued his misconduct and gross disobedience to service rules and regulations, which earned him more queries and punishments. The claimant, while in the service, was a recalcitrant, discreditable staff who had high disregard for service rules and regulations. The claimant's 19 years of service had unprecedented record of blemish and conduct unbecoming of a member of a highly reputable organization such as the Department of State Service. The claimant was reprimanded on many occasions for his misconduct. The defendant admitted involvement of claimant in an accident, but denied claim of the claimant that he went into coma and no nurse proposed amputation of his leg. From the claimant's medical record, he was admitted for 5 days and was diagnosed with fracture of the left femur. The treatment option proposed by surgeon was reduction and internal fixation, but the claimant declined and prepared to be treated by the traditional bone setter. The claimant had no permanent medical disability as the defendants continued to malinger and absent himself from work with no reasonable cause, which earned him more entries in his confidential file. The claimant on 20th day of November 2015 visited the defendant's clinic to obtain excuse duty using his fractured leg when he was advised by the doctor on duty to accept referral to the university to see a surgeon for proper examination at the University of Calabar. He declined. The claimant in February 2016 applied for annual leave in total disregard of the policy on annual leave. The claimant's application was not approved but kept in view. The application for leave was kept in view because it was made outside its schedule of annual leave for the year 2016. The claimant, after submissions of his application for annual leave and without confirmation of outcome of his application and his usual disguise of constituted authority, abandoned his duty post from the 8th day of February 2016 to 9th day of March 2016, informing no one of his whereabouts. Consequently, on the 1st of March 2016, the claimant was declared deserter after a period of 21 days of absence. Due to the continued misconduct and flagrant disregard of the rules and regulations and desertion from work on the 18th day of July 2016, and claimants a punishment of dismissal from service in line with the laid down procedure and laws guiding the defendant. The claimant, having been dismissed from service, is not entitled to pension or any emolument or damages from the defendant. A reply to the defendant's defense, the claimant never served with a query, letter, nor tried for the offense of desertion to date by the defendant. Furthermore, claimant maintained that, assuming without considering he committed any offense bordering on the religion of duty previously, he has been admonished and punished administratively and accordingly. Such past cannot form the basis of fresh allegation of desertion, as it were. It is for the defendant's medical board to declare claimants medically fit, since they are not the ones treated him. He applied for annual leave to enable him to be stable in his village where he was undergoing traditional bone setting treatment. He was granted annual leave from 8th February 2016 to 8th March 2016. Was to resume on 9th day of March 2016. His approval for leave was published on notice board, and he was orally communicated by the officer in charge to proceed to his leave. Claimant admitted that he was declared disaster but was not communicated to him. Reason because he had already commenced annual leave granted to him by about his approval for leave was published on notice board, and he was orally communicated by the officer in charge to proceed on his leave. Claimant admitted that he was declared deserter, but was not communicated to him. The claimant maintained that due process was followed in dismissal of the claimant from duty. The submissions of the dependent. The dependent formulated two issues for determination. The issues and argument on these issues have been captured in the body of the judgment. So I will skip reading the submissions of the counsel for the dependent on the two issues formulated. Then I go to submissions of counsel for the claimant. The counsel for the claimant formulated three issues for determination. The three issues and the argument were captured in the body of the judgment. So I will also skip reading the submission of counsel in the I now goes to the decision of the court. Yes, I have considered the processes filed in this suit, the evidence made by the parties, as well as the written and oral submissions of counsel for the parties. It is my view that what this court is to determine is from the evidence adduced by the claimant, can it be said that the claimant has proved entitlement to any of the reliefs being sought? The claimant is seeking for four reliefs. The first relief is for declaration that the dismissal of the claimant of 18th day of July 2016, not having been given opportunity to be heard, nor queried for once, is unfair, unjust, unconstitutional, illegal, null, and void. This is the main relief in this case. This is one of the main reliefs in this case, while the second and third reliefs are ancillary, dependent on the grant of the best relief. The fourth relief is an independent relief, which is based on Employee Compensation Act. From the facts and evidence it is common ground that the claimant was employed by the defendant in 1997 as a spy guard and rose to the rank of Chief Kai. The position on which the claimant was dismissed from service, see Exhibit C1, by the paragraph 3 of the Exhibit C1, by paragraph 3 of the Exhibit C1, the claimant's letter of employment, it is clear that Exhibit DB and DD, the regulation governing the employment of staff of the claimant, NSO regulations of 1981, circulars and civil service rules, all govern the employment of the claimant. However, in event of any conflict between the provisions of Exhibit DB and other It is evident that the claimants and the claimants the claimant's employment is subject to the provisions contained in Exhibit DB and DD, circulars and civil service rules. But in event of conflict, Exhibit DB prevails. It is also not in dispute that the claimant's employment is one that has statutory labor because it is governed by rules and regulation driving their post from the statutory provisions as constituted. See the case of Olanian versus University of Lagos, reported in 1987, part 9. Both the claimant and the defendant are bound by Exhibit DB and DD regulation governing the employment of the claimant. On 18th day of July 2016, the defendant issued Exhibit C6 letter of dismissal to the claimant after the claimant had been declared deserter as per Exhibit C5. There is no evidence that after the claimant had been declared deserter, he was not queried or tried for offense of desertion. The defendant insisted that the dismissal of the claimant from duty following due process as a law regarding desertion from death the claimant's employment being one that has statutory labor is such that for any disciplinary action to be taken, the action must be in conformity with the letters of the law or the regulations. The genesis of the dispute that brought about the current case is as contained on 17th day of June 2009. The claimant, while in the vehicle belonging to the claimant, being conveyed together with others to their residences after close of work had accident, which resulted in his left leg being broken. He was hospitalized for 6 days and he opted for local bone setter. The claimant had relied The claimant had relief, but not total, as he has to be limping his leg, which is a permanent disability. February 2019, the claimant sought permission from the office to travel to his village for treatment of his leg. The approval for the leave was granted, but surprisingly, barely 15 days into his leave, he got a distress call from his office in Calabar urging him to hurry back to command as a team from Abuja have come for staff verification. But before claimant could limp his back to Calabar, the team has left and gone back to Abuja. The claimant resumed duty and was collecting salaries without any query, trial whatsoever. At the time of his dismissal from service, he had still 3 more years to serve, as he was due to retire in 2019. The claimant has written several letters of appeal to the defendant, but to no avail. The defendant, on his part, maintained that the dismissal of the claimant was possession and the due process was followed as contained in Exhibit 153, in Section 153 of Exhibit DB. The conditions of service: the claimant, while in service was recalcitrant, disgraceful, who had high disregard for service rules and regulation. The claimant in 2010 faced medical, but he was found satisfactorily all right and was asked to resume his duties. The claimant leaves application for leave was in disregard the dependent policy on leave. The claimant was declared deserter on 1st of March 2016 after having absented himself from work for more than 21 days. Claimant continued misconduct of flagrant disregard for rules and regulations from work entered it is glaringly clear that the defendant's regulation governing his relationship with employees, Exhibit DB, in Part 19 or in Part 9, had made provisions for procedure in handling direct disciplinary infraction by personnel of the state's security service, including the claimant. In this case, I quite agree with the counsel for the claimant that proper appreciation of the law Exhibit DB must be holistically and altogether considered, and not some section in isolation. This approach is in tandem with the extant provisions of the law on interpretation of statutes. I have carefully perused the entire provisions of Exhibit DB, and it is clear to me that Section 153 of Exhibit DB was specifically made to govern desertion from duty by a junior member of staff, the defendant. The claimant being the claim by Section 153 of Exhibit DB, offense of desertion it is clear from the provisions of Section 153 of Exhibit DB that a desertion with which the claimant was accused of committing is punishable by dismissal from service without the defaulter having to be queried or undergoing legal proceeding. Desertion is an offense once committed. The officer automatically rendered himself liable to be dismissed without much ado. See the case of Palomo versus Lagos State Service Commission and another. The rationale behind this provision is because data could not be found dealt with in line The rationale behind this provision is because its data could not be found to be dealt with in line with the normal provisions for discipline members of staff. Due to his absence, which would make it difficult for him to be reached, or to be served with a query, or to be invited to appear before a committee to answer charges or offenses against discipline. In the case at hand, CW5 shows that the claim was declared disaster Case at hand, Exhibit C5 shows that claimant was declared deserter on the first day of March 2026. This declaration has rendered the claimant liable to be dismissed from service as per Section 153 of Exhibit DB. However, the claimant insisted that despite having been declared deserter on first day of March 2016, the defendant did not deem it fit to dismiss the claimant with immediate effect. The defendant did not also align with the provisions of Section 153 subsection of the DB struck out the names of the claimant from the nominal role of the defendant, as from the date the claimant was declared deserter. The defendant has equally failed to stop with the accrual of pay to the claimant as evidence The claimant insisted that he did not desert his duty because he was granted leave by the defendant to commence, which commenced on 8th day of February 2016 and on 8th day of March 2016. However, there is no iota of evidence adduced to establish that the defendant granted the claimant his application for annual leave. The application of the claimant for annual leave, which was recommended for approval, was never approved at the line or column where the approval is to be given remains empty. I quite agree with the defendant that the claimant, though made an application for leave, did not wait for the approval of his application. He went ahead to start the leave before getting the requisite approval. The claimant has also insisted that it was the officer in charge that told him that his leave has been approved and he can proceed on his annual leave. However, the said officer was never called as witness in this case. Therefore, the claimants claim that he was granted leave has not been established, and that has been announced by this court. From the evidence before me, the defendant who is statutorily bound struck out the criminal role after his declaration as deserter failed and neglected to do so. The defendant equally failed to stop the accrued pay of the claimant continued receipt of his salary. From the evidence before me, the defendant who is statutorily bound to strike out the name of the claimant from nominal role did not, as deserter refused to do so. The defendant equally failed to stop the accrual of pay for the claimant as the claimant also continued to receive his salary despite being declared deserter. The excuse given by the defendant that the payment was made due to technical error. However, the defendant has not told this court what that technical error was that made the claimant to be paid his salaries despite being declared as disaster. Based on this revelation, I have no choice than to totally agree with the submissions of counsel to the claimant and the authority Mundayo versus University of Ibadan and the case of Nigerian Army versus Brigadier General Mondi and Khan. The defendant condoned the desertion against the claimant, the declaration of desertion against the claimant. This means that with the condonation, the defendant is stopped from dealing the claimant as a deserter, as the claimant has done the act by continuing to pay claimant his salaries despite being declared a disaster, and also refuse to strike out the name of the claimant from his nominal role, despite being obligated by the provisions of Exhibit DB, which is a statutory instrument. The law is now well settled in a long line of cases that where an employer who, upon becoming aware of having knowledge of an infraction, conducted misconduct or wrongdoing, choose to condone same, he may be stopped from relying on same in future to dismiss the employee. In the case of the University of Ibadan, see also ACB versus BCK, see also Nigerian Army Brigadier General Mondi Aminu Kano. In view of the foregoing, the dismissal of the claimant from service cannot stand as it was not done in line with the extant law and regulation governing the employment of the claimant. It would have been a difference if the dismissal of the claimant was done immediately from the evidence before me. The defendant had to defend itself for the lax and snail speed with which the disciplinary procedure for discipline of the claimant was handled. This should serve as a wake-up call for diligence and tardiness in carrying out disciplinary discipline of members of staff of the defendant. This means claimant never left service of the defendant. However, with the revelation that the claimant ought to retire from service in November 2019, the claimant is by operation of law deemed to have retired in 2019. Relief 3 is claim for special damages that needs to be specifically pleaded and strictly proved. The claimant has failed to strictly prove entitlement to some of these monetary claims, which are special damages claims. The claimant having been the claim or relief for is predicated on personal injury sustained by the claimant as a result of ghastly accident, motor accident, which resulted in claimant having his left leg broken. The relief is based on Employee Compensation Act, clearly and totally incompetent and misconceived as this court by virtue of Section 12 of Employee Compensation Act does not have the right or power to grant compensation under the State Act. It's only the Board of National Insurance Trust Fund that is empowered to grant compensation, all of which the role of which this court is affiliate, where the employee is granted by the award of compensation if he is dissatisfied with the award. He can appeal to this court by way of appeal. See Section 54 of the Employees Compensation Act. With the continued payment of claimant salaries by the defendant after declaring him as deserter, as per Exhibit C5, the defendant has condoned the act of desertion by the claimant from the foregoing revelations, and for clarity's sake, the order of the court is as follows. with the continued payment of claimant's salary by the defendant after declaration of claimant as deserter. As per Exhibit C5, the defendant has condoned the act of desertion against the claimant. Therefore, the dismissal of the claimant from service on ground of the desertion cannot hold waters, cannot stand, and is hereby set aside. The claimant is hereby reinstated back to his position as chief guard detective with all entitlement. Let me say at this juncture that the grant of reinstatement means this court will not grant the alternative order. And the law is that once the main relief is granted, an alternative reliefs cannot be considered and granted by the court. In the alternative relief, the claimant is praying this court to retire him from service due to a obligation of time with effect from November 2019. As I pointed out, my hands are tied with the grant of the main reliefs, which the law requires me to best almost consider. It's only if that relief has not been granted that this court would have considered the issue of combating the claimant to retirement on ground of old age. What all this means is that the drafting of the prayers by the council for the claimant was clumsy and were done in a confusing state. They were also vague. In the circumstances, the alternative reliefs cannot be considered by this court. The the claimant has also prayed the court to grant him salaries in the sum of 150,000 per month from the date of his dismissal, November 2019, when he would have retired from service. The claimant has not adduced evidence to prove that his salary is 150,000 per month. And in Fee 13, the statement of account which was tendered by the claimant was electronically generated. It has to comply with Section 84 of the Evidence Act. Having not complied with the provision of Section 84 of the Evidence Act, the claimant, having not complied with Section 84 of the Evidence Act, it has no evidential value. Even if the statement account has not been found not to have evidential value, it cannot be of any assistance to determine that the salary of the claimant is 150,000. As I have gone through the said statement account, I cannot find where the salaries of the claimant was stated 150,000 naira. However, since the claimant's employment is one that is below statutory labor, is entitled to his salary upon the finding that his dismissal has not been properly done. However, the quantum which the claimant is claiming has not been proved. That reliefs having not been proved cannot be granted. There is also claim for 15,000 naira monthly incentives, which is being claimed to be from the date of dismissal to November 2019. Incentive is an entitlement. Since it is an entitlement, the claimant has a duty to prove that he is entitled to that claim on the merit. There is no evidence adduced by the claimant to establish that he is entitled to any incentives, monthly incentives of 15,000 naira. There is no cogent and compelling evidence that the claimant adduced to prove that incentives. Being a claim for special damages, it has to be strictly pleaded and strictly proved. Since there is failure on part of the claimant, strictly the incentives, that head of claim fails and same is thereby dismissed. There is also the claim of 20 million naira being physical, social, and mental compensation package. This relief also has not been being claimed for special damages, has not been strictly proved by the claimant. There are no cogent and compelling evidence adduced by the claimant to prove entitlement to 20 billion naira for physical, social, and mental compensation. There is also relief for us, which is a claim that is based on injury sustained by the claimant. The claimant is basing this claim on employee compensation Employee Compensation Act. The Employee Compensation Act has clearly made provisions for the person that has the locus to grant compensation. It is the Board of National Insurance Trust Fund, not the court. The court can only be approached on appeal if the employee is not satisfied with what was granted to him by the court. In this case, having not approached the court, the reliefs is asking based on employee compensation and is incompetent, the same by dismissed. It is clear from the foregoing that the only reliefs which the claimant is only able to establish his first and second relief, while all the others have not been proved due to lack of evidence to support them. As pointed out earlier, it is the drafting of the reliefs that caused the claimant to lose some of them. The court is bound by the reliefs put forward by the claimant, and the court is not enjoined or entitled to make a case for a party or to grant him a relief not to claim. The claimant, having not made claim for reinstatement or having not made a claim for retirement as an independent relief, having not made an independent relief concerning retirement, has deprived of himself of what he would ordinarily have been entitled to if proper reliefs or claim has been made in that respect. From all I have been saying above, claimant is only able to establish that his dismissal from service is wrongful for having been made after he has been after his declaration as deserter has been condoned by the mere fact that the claimant is a persistent or consistent lawbreaker as regard to the rules and regulations of the defendant cannot be a ground based on which this court can sanction the claimant. All those previous acts of misconduct by the claimant have been treated and appropriate sanctions have been imposed by the defendant. They cannot in this case be brought again for the claimant to be punished for the second time. It is clear from the evidence before the court that the defendant failed to perform its duty in the way and manner it is supposed to have done. If the defendant has been often doing concerning its rules and regulation and discipline of staff, the claimant would not have survived up to now. Up to 18th of July 2016, when he was purportedly dismissed. There have been several infractions of the rules and regulations by the claimant, but the defendant continued to condone them and treated the claimant lavishly with good kid gloves. That's why he continued with his act of misconduct. However, there is nothing this court could do since the claimant's employment is one that has statutory labor, in which the requirement is that there must be total, complete, and strict compliance with the procedure for any dismissal to be declared valid. In the case at hand, the defendant would have succeeded in the dismissal of the claimant if the dismissal was followed immediately with the declaration of the claimant as deserter. However, the defendant, having waited and continued to pay claimant salary, has discredited his duty and has now empowered the claimant to have his job returned back to him, as his dismissal is declared null and void and of no effect whatsoever. This is the judgment of the court. The judgment is entered accordingly, and I make no order as to cost.
As the court pleases.
As the court pleases.
My Lord, we appreciate you for this well-considered decision.
You are welcome.
We'll study for necessary action.
Yes. Yes, counsel, you are free to go.
Thank you, my Lord.
You are free to go. Registrar, call the stood down matter.
As the court pleases. Suit number NICN CA 19-2021 between Nigeria Social Insurance Trust Fund Management Board and Lafarge Africa PLC. My Lord, the parties are absent.
Yes.
Your Lordship, Aliu Jibril,
Yes, same appearance.
same appearance for the defendant, Your Lordship.
Yes.
Your Lordship, I indicated
The defendant is still not not online.
the claimant.
The claimant, sorry. The claimant.
I talked to him now, and he sincerely apologized for his absence because he's indisposed, which he said he has communicated to the registrar. I called him, he said he has communicated to the registrar that I should go ahead
Okay.
and yes, ma'am.
Okay. Yes. Registrar.
Yes, my Lord, it's true.
Have
Mr.
you got-
Izechi called. Mr. Izechi called, my Lord.
Okay.
Yes, my Lord.
Counsel for the claimant, Mr. Ezechi, called and said he is indisposed to appear, but the court can go ahead with the adoption of the terms of settlement. Is that correct?
Yes, my Lord.
Yes, Mr. Jibril.
Yes, my Lord. My Lord, the parties have settled and their terms of settlement have been filed. The terms of settlement is dated 16th of June, 2023. Your Lord.
You say it's dated
16th of June, 2023.
yes,
And filed on the 19th of June, 2023.
Okay.
Your Lordship,
Yes.
parties have signed the terms of settlement
Yes.
and wish to adopt same as consent judgment in this suit, Your Lordship.
Yes, this is my judgment. I have listened attentively to submissions of counsel for the defendant, adopting the terms of settlement executed by the parties. In the circumstances and in view of the message sent by the counsel for the claimant, the terms of settlement dated 16th day of June 2023 and filed on the 19th day of June 2023 are hereby entered by this court as judgment binding on the parties like any other judgment of this court. The terms of settlement will serve as final and full settlement of all issues in dispute between the parties. In the event of default, any of the parties in this suit can set machinery in motion to enforce the said consent judgment. Judgment is entered accordingly.
As the
Thank you.
court pleases.
Yes,
I'm most obliged.
you are welcome. Registrar, any other
No, my lord, that's all for today.
Okay, then what our ruling would be on Monday.
Yes, my lord.
What time?
My lord, maybe 9 or 12.
No, put it for 10. Let it be 10 o'clock.
Yes, my lord.
Let it be 10 o'clock. Note
Yes,
it.
my lord.
Wherever you move. 10 o'clock on Monday by the grace of God.
Amen.
Huh?
Yes, my lord.
Okay. Thank you. Any other issue?
No, my lord, that's all for now.
Okay. Okay. Have a nice day.
And you too, my lord. Thank you, my lord.
Administrator, you can discontinue with the sitting.